Hey everyone, I'm finally back and we are just going to jump right in because we have so much to cover today. My last episode was just a very quick response to Blake's motion to dismiss. It was the night before my surgery. I didn't have a whole lot of time, but I was getting messages and comments of people who were worried that Blake had found this incredible loophole that gave her some kind of outrageous privilege based on Rule 47.1. We're going to start with that. This is a new rule. It's not even been used in any case yet that I've been able to find. That's how new it is. Now, it could relate to this case because of the case type and if the case falls under California law because it's a California rule. Now, does it spell good news for Blake? Does it strengthen her case? I've seen some speak like it's a magic wand that can be waved and that Blake will automatically win. But that's not the case. It's not even time to really be thinking about this rule, first of all. But secondly, there's nothing in it that helps Blake bolster her claims. This rule is not even for the judge to be applying right now. This rule is meant for a jury to apply at the end of a case. In Blake's case, she would have to win first. It's not going to help her win. It determines damage amounts if she wins. So if Blake wins, the jury can decide to apply these extra damages from this rule. These treble damages. My Murdoch crew may remember when we discussed punitive damages and treble damages back when we were talking about the last of Alex's money being sorted. There were applications made by different attorneys, two of which were Eric Bland and Mark Tinsley. They had worked up formulas for what was owed to their clients. In those cases, there were some specific South Carolina state rules that would lead to the same thing we're talking about here, treble damages, or these damages that are tripled in their amount. These types of damages are called punitive damages because rather than actual damages for things that you lost, these are given as a punishment to the person or company in such high amounts so as to deter them from ever doing these kinds of things again. So, this rule, like the rule that was applied in that case, the case has to be won. The jury has to have been given this rule that they could possibly use to determine damage amounts. That's all this rule is. So everything about this rule has been mischaracterized this past week. Another situation that I heard that people were questioning is whether or not Blake had the right to sue in federal court since her CRD was filed and only offered her the right to sue in a California state court. Now, what's this all about? When she filed her original complaint, she filed it with the Civil Rights Department of California. When you file these types of complaints, you have two options. One, you can wait for the Civil Department to investigate your case by themselves, which often takes years because they're very backloaded, or you can request a right to sue with your own lawsuit. Now, when she filed her CRD complaint, she did request this right to sue, and they gave her one, but it clearly said that it gave her a right to sue in a California state court, that if she wanted to file a federal lawsuit, she would have to file a complaint with the EEOC. People are assuming that she didn't file this EEOC complaint and simply took this right to sue from the CRD and filed her federal lawsuit. Now, if she did that would be a problem because the document clearly says that it doesn't give her the right to file in federal court. But just because we haven't seen an EEOC complaint doesn't mean there isn't one because this type of complaint is confidential. We have no way to look it up, no way to verify whether or not she filed one. Even an employer who this sort of complaint is filed against is limited into what information they can discover. An employee can sue them anonymously. So this information is very protected. We won't know whether or not she filed this unless that information somehow comes into court filings or is spoken about by one of the parties in the lawsuit or one of the attorneys. The filing is the same with the EEOC, where you can ask them to investigate or you can ask them for the right to file a lawsuit on your own. But while we're on this subject, there is something I want to mention. And that is that it's very odd that she bothered with filing the CRD in California in the first place if she was going to file a federal lawsuit out of New York. Now, why would she do this? There is a limited amount of time to file a charge of discrimination. You only have 180 calendar days from the day the discrimination took place. That's only 6 months. This harassment that she alleges happened she claims happened in the first section of filming. That ended when the strike took place, in the summer of 2023. Early summer, we're talking June. The deadline to file on that in a federal court would have been December of 2023. Now, there's an extension to 300 days if the state or local agency enforces a law that prohibits employment discrimination on the same basis, which both California and New York do have. But even 300 days, if this was supposed to have happened in May or June of 2023, even that 300-day filing deadline would have expired by April of 2024. And we know that Blake didn't file a complaint until December of 2024. So honestly, it looks like she was past the statute of limitations to have even filed this lawsuit in federal court. So this could be the reason that she filed it first in the state of California, because in California there's a 3-year time frame for harassment claims. It's the same with the retaliation action. You have 3 years to file from the retaliatory action. By filing this CRD, was she possibly trying to allow for a 3-year extension? And does that qualify? I think that's something definitely the attorneys need to look into to find out whether or not her filing in a federal court met with the statute of limitations. Now, another bit of housekeeping is about Blake having signed through her corporation instead of as an individual, and people were guessing that that meant she was not employed by Wayfair. Now, we have to think about this logically for a moment. If loopholes for responsibility were this easy, no one would hire direct employees, because then they could just avoid liability. Everything would be subcontracted. It's still a work relationship. If there's a problem with one of your subcontractors, both of you are under fire because you contracted them. You will still bear responsibility, and it is still a work relationship. So even though Blake signed through her incorporation, it's still a work contract. So there is no loophole here at all. So now we've cleaned up some of those rumors. Let's move on into the documents. Now, if we look back at the scheduling order chart that we made many episodes ago, we have the main scheduled items, but along the way, we'll have lots of little things to add. Now, we already went through that the first documents filed in a suit are a summons and a complaint. In this case, there are so many. Now, whenever these are filed or when they are amended, we have to add some new dates to the schedule because each of these documents have a date that they must be responded to by. In some cases, it's 14 days. In some cases, it's 30 days. But these are dates that are given by the court so that everything moves along in a timely manner. Now, I'm sure you noticed as you look through these complaints that all of the paragraphs are numbered. These are numbered for easy reference, and one of the main reasons they're numbered are these documents we're going through today. They are called the answers to the complaint. So every defendant that was listed in the complaint had a certain number of days before they had to file an answer. Now, these all got dumped. It's not usually so difficult, but we have so many plaintiffs and so many defendants in this case. And this batch was in response to Blake's amended complaint. Now, Team Justin didn't file any motions to dismiss. They won a trial. This is gutsy and it's smart because one of the downsides of a motion to dismiss is that you kind of show your hand. You show pretty early on how you intend to defend your clients. And we saw this with Ryan, with Blake, with the New York Times, with Leslie Sloan. We saw Ryan's go way too far where he brought up things that weren't in the original complaint, which you're not supposed to do. And it was really quite foolish. Team Blake mocked Team Justin for not filing motions to dismiss, saying that they couldn't file them because they had no legal leg to stand on. The truth of the matter is, what Team Justin did was very smart. Motions to dismiss are rarely granted. Very, very, very rarely. I mean, attorneys know when they're writing them up that they're wasting their time. So Team Justin said, we're not even going to bother with that. We're not going to show you our hand for something that's not going to happen anyway. But thank you for showing your hand because we saw every legal argument that they're going to fight. So it's like in sports, you see the other team's tactics, their plans, their formations, the plays, all of the behind the scenes stuff that they like to keep private. Team Blake has now bared all that, but Team Justin, theirs is all still secret. Of all the motions to dismiss, only the New York Times actually ever had a chance at that. I'm hoping that with the memoranda that was filed by Team Justin, that they don't have a chance on that anymore, but we'll have to see. But answers, unlike motions to dismiss, are not optional. Not only must they be answered, but they must be answered truthfully. Especially this early on in the game, you don't want to give too much away. So even though they must be answered honestly, you want your answers short and sweet. And at all times thinking about how to cover your client now and in the future by what you say in these answers, because these answers become part of the litigation record. If you slip up on these, your answers can and will be used against your client from here on out. Now, at the end of the section where you give an answer to each of these numbered paragraphs from the complaint, and that section is answered with admissions and denials and very short statements, there's also a section for defenses. These defenses can be things like we've already seen: lack of subject matter, wrong jurisdiction, improper venue, failure to state a claim. There can be counterclaims, cross-claims, and we have a special one we're going to talk about later today. So though these documents are so long and they took hours to print, there isn't usually much new information on them. We go through paragraph by paragraph, and again, that's why they're numbered, so that you can refer easily back to the complaint to see what's answered. They're not an exciting read, especially to spectators, but they're important for the attorneys to read, and to read these as side-by-side comparisons so that nothing gets missed. So in this case, we have the complaint, and then we have 8 responses to that complaint. So it was like a big old flipbook festival comparing all these answers. There's nothing earth-shattering in any of the actual answers, but in the section for defenses, and most of these are known as affirmative defenses or equitable defenses, they're a stretch too, but if you don't raise them in your answers, you waive your right to ever raise them. So often as many as possible get raised. It's rare that anything comes from raising them, but cases have been dismissed based on them. And in a lot of cases, the decisions to dismiss are often held up in appellate courts. So it's always worth a try if you have a good case for these defenses. Now, in Justin's answers alone, there were 29 defenses listed. A lot of them sound like duplicates, saying that Blake wasn't actually damaged by any actions done by Justin. But we're going to dive into a few of them that were mentioned that I feel really could possibly apply to this case. The first one was raised as the 4th defense, and it's estoppel. This is a doctrine that prevents a party from acting inconsistently with previous words and actions by a party. So, say a party makes a statement, the other party relies on that statement, the original party cannot make a claim that contradicts what they stated before. Now, there are 4 requirements for it to be estoppel. First, there has to have been a clear and unequivocal statement or action. 2, there has to be reliance by the other party on this statement or action. 3, the relying party must have suffered some detriment by relying on the statement or action. And 4, there has to be some injustice where it would be unjust for the stating party to go back on the statement or action that they made. Basically, you can't make a claim that contradicts what you said before. One of the things I was thinking of involves Jamie Heath. One of the early complaints that Blake says she made was accusing Jamie Heath of making eye contact with her while she was breastfeeding. This is one of the things she brought to Sony's attention when she says she claimed sexual harassment. Now, this was addressed back at the time. She was breastfeeding, they were having a meeting, she asked for them to look away, and at some point in the conversation, she said Jamie made eye contact. He says he didn't even realize that he had done it. He apologized for it. She said to him at the time, "I know you weren't trying to cop a look." This is a clear and unequivocal statement. Remember, that's the first requirement. The second requirement is reliance by the other party. He relied on her statement that she understood that he was not trying to look at her. And it's interesting that the accusation doesn't say he tried to look at her breasts, but that he made eye contact with her. So for her to now add this as part of a lawsuit after making this statement, saying that she knew he wasn't trying to do this, then accusing him of trying to do this, to me, that falls under this doctrine. And what these doctrines are for, they're called equitable defenses because they're all about keeping fairness in court. Laws can be very black and white. Sometimes you need something in addition to laws to keep the court fair and equitable. And that takes us right into the 5th defense, And that's that they say Blake is acting with unclean hands. And this is yet another equitable defense. So, to try to explain this, in black and white terms, if there's a case that comes before the court, the plaintiff says, I'm suing my neighbor because he burnt my garage down. Under the law, what the neighbor did was illegal. It's very clear he should have to pay for this garage being burnt down. But let's say in this case, he burnt the garage down because that particular neighbor put sugar in the gas tank of his brand new car and destroyed it. Now, would that be fair to punish just the one? This is what an equitable defense is for. You can use this doctrine of unclean hands. Say, hey, judge, yes, I burnt down his garage, but I did it because he destroyed my car. So he doesn't have clean hands either. The judge can decide you both acted illegally, you both cost each other money, you both have dirty hands, your case is dismissed. Whereas if someone comes in and their neighbor burnt down their garage and they hadn't done anything, the victim has clean hands and deserves to be awarded money for his garage being burnt. So these keep the court fair. But they're not actual laws. They're more like principles to help decide something. So in this case, Blake's saying he had this smear campaign against me. But Team Justin's saying, you defamed me to the New York Times. You defamed me to the rest of the cast by whatever it is you told them that turned them on me. You set the tone for how we were going to speak with one another by things that you said, things that you texted, and when we used the same exact language back to you, you called it harassment. You don't have clean hands. How are you going to sue me for something that you did to me as well? So again, this seems very possible in this case. Now, as it's described in this defense, it says that Blake failed to bring the causes of action in a timely manner, and she's therefore barred from recovery against the defendant. Now, this sounds like another affirmative defense, the statute of limitations, but it's different. A statute of limitations is only based on a time limit. So, like we talked about with her filing this in a federal court, we saw that she only had 180 days to do that, unless there was a state law that could extend it to 300 days. These are very clear statutes of limitations. You have a year, you have 2 years, you have 3 years. Then you cannot bring this claim to the court because it's just been too long. That's not what Laches is. Like the other equitable defenses, it requires some kind of shady behavior on the part of one of the parties. It's not just waiting, but it's making an intentional delay to your case to help you in some way. There are 3 requirements to it. 1 is that there is a delay. 2, that this delay is unreasonable. And 3, that something about this delay prejudices the defendant. So, for example, the statute of limitations works is because in time, witnesses can kind of forget things, forget exactly what happened, forget exactly what they saw. There's nothing intentional in that. That's just kind of the way it is. But Laches would be, say your prime witness has a terminal disease, and you know it, the prime witness against you. So you intentionally delay until that witness has passed away and can no longer testify against you. That has nothing to do with the amount of time you waited. It's the intent behind delaying to make sure that something helped your case. How can that be applied to this case? Blake waited. One finds it hard to believe that a powerful person like Blake, who had these powerful dragons, who has SAG-AFTRA on her side to defend her, who has sued a person in the past that she thought was looking at her or recording her or doing something weird to her. It's always seemed weird to me why she waited to file a complaint. This matter could have been very clearly, cleanly decided, sorted a long time ago by taking it straight to SAG-AFTRA. She acted like she was so confused about how to file a complaint that she tried with Sony, but Sony said, oh, you have to do this to Wayfair. And supposedly, she couldn't file it with Wayfair because, well, what could she do? Because it was Justin and Jamie. None of that made sense to me because we've seen how she operates. She doesn't operate like helpless, oh, I just have to put up with this person. And I don't believe that Sony would be so nonchalant about a sexual harassment claim. Because you know what Sony could know? You take this straight to SAG-AFTRA. They're your union. They have a whole department on this. They've got tons of printed material on this. I showed it in my last episode. There's a reason Blake waited. She went on with filming. She flew Justin in her private plane. She had Justin in her home. Many months later, she sat alone with him in the editing bay. She didn't avail herself of the use of a body double for sex scenes, even though it was offered to her. She didn't do anything that you would expect a person to do if they were actually traumatized by some sort of sexual harassment. But then suddenly, once the film was all finished, and she had taken the editing, had an actual reel of her version of the film by her own admission that she flew around with in her purse, showed it publicly. Once she had all of that, that's when she started making moves. But even then, it wasn't the one move that she should have been making if her accusations were true, filing a claim. So she was delaying all this. But what happened during all of this time of delay, this 1.5 years of delay? All of a sudden, the cast, who formerly adored Justin, and we see it in their text messages and interviews, whenever they talked to him or about him, it was so favorable. And then, once Blake had completely stolen the movie, she started flying the cast around with her. For example, the book Bonanza. That was supposed to be Justin. Then instead of Justin, it was Blake all of a sudden, attending with Colleen. But who does Blake bring with her? All the rest of the cast. She starts having them to her home. She has little sleepovers. She starts lending out her clothes and jewelry. Starts promoting Brandon. She's seen out in restaurants with them. They get invited to Deadpool events. Brandon gets to do a little promo with Hugh Jackman. All these wonderful little favors. Now all of a sudden, the cast can't stand Justin. We know that they liked him when they worked with him. And now all of a sudden, they won't have anything to do with him. They unfollow him. There's only one explanation for why that happened. Blake had to have said something to them to make them think poorly of Justin. Now think about this. You can't really fault them in the beginning. Because if you know someone and you think that person's really nice and really great, you have no reason to dislike or mistrust that person, and they tell you this traumatic thing happened to them, especially as a woman, if one of what we think are our friends, tells us that she was sexually harassed, we're naturally, defensively going to hate the person that she says did it to her. We have no reason to think she's lying. We're shocked. We're appalled. We believe her. We support her. Of course, we don't want her to have to be anywhere near the guy who did it to her. We're going to be protective. We're going to make a public stand against him because that's a terrible thing to do to someone, right? What else happens besides turning the cast against them? Her little breadcrumbs. Leslie Sloan dropping stuff to the media. Still, after all this happens, she's able to tell her co-stars, but still no complaint is filed. And now we're 1 year after it supposedly happened. Past 1 year after it happened, we're in August of 2024. When this supposedly happened in May or June of 2023. No complaint, still being delayed. Then in October, at least by October, we know she's in contact with the New York Times. She's sharing these cherry-picked texts that Stephanie Jones obviously cherry-picked before handing over to Blake. So twice cherry-picked. Blake tells her side of the story. This article gets written. Still, no complaint. Finally, the day before the New York Times says, we're ready. We've got the article written. We've got the video made. We're dropping it tomorrow. Finally, Blake files her complaint. So she delayed that complaint, even while she was telling her co-stars, even while she was telling the New York Times, even while her PR rep is telling the media, she still hadn't filed the complaint. Why? So she could get all of this on her side. If she had filed a complaint back when she claims that it happened, and all of these people had to testify for her, the story they would have told on the stand would have been very different than the story they then would have told by the time she filed the complaint. Because what had happened by then, she had turned him into a monster. So not only has she told them this herself, but now there's a New York Times article out there. And the New York Times lays it on heavy. We've seen these thousands of pages of texts and emails. These things were subpoenaed. It all sounds so official, so believable, that these potential witnesses, these cast, now they not only have the things that Blake has told them about Justin, but there's this huge New York Times article about Justin and a video to go with it that says, hey, this information was subpoenaed. Hey, this information was verified. Hey, this is filed. Now, what's happened to Justin's reputation? It has effectively been destroyed. Now these witnesses, the way they look at Justin, now if they're going to sit down and testify in court, what are they going to say about him? Every single action that they saw at the time they knew him, that probably seemed innocent, that they didn't even question, now that they've heard all of these terrible things, they're going to look back on it with a different thought in mind. Not only that, it all happened back in 2023. So their recall is not clear, and it's now been clouded by this reputation that she's put out, very carefully crafted over all of this time, that she didn't file a complaint, didn't file a lawsuit. And what were those 3 requirements again for Laches? A delay that is unreasonable, a delay that prejudices the defendant. Is that not exactly what she did? She didn't file a timely complaint. She didn't file a timely lawsuit. She delayed it, and during that time did everything she could to prejudice the world, so the future jurors, and also the future witnesses, the cast. Then she filed it. How is this not Laches? Isn't this exactly what this equitable doctrine is put in place to stop from happening? To keep fairness in the court? Has she ever given a reason why she delayed so long? In all those months that she had the time to be spilling her guts to the cast and spilling her guts to the New York Times, she didn't have the time to get her lawyer involved to file this complaint. She ended up going past the initial 180 days that are granted by a federal court, the 300 extended days that are granted if there's a state law as well. She went past all of that. Why? She was doing tons of damage behind the scenes to Justin, but not the one thing that really mattered. She didn't do that until she had that New York Times article locked, loaded, safety off, ready to fire. Then she filed her complaint. Any reasonable person who looked at it through this doctrine would come to that conclusion. It's not like she sat quietly suffering and said, I can't take it anymore. I'm going to do something about this. And then she went straight to the court. That's not what happened. But like I said, there are 29 of these defenses listed in these answers, and I hope these get taken seriously because, like I said, these 3 here, the estoppel, the unclean hands, and especially this Laches doctrine, I honestly think these could truly be applicable in this case and should be pursued a little bit. Now, besides these defenses, there was a special surprise I mentioned earlier that came up in these answers. And that's the very last one. So these answers were given by Justin, by Wayfarer, by the movie itself, by Jamie Heath, Steve Sorowitz, the agency group, Melissa Nathan, and Jennifer Abel. Now it's Jennifer Abel's that gives us the little sweet surprise, because hers isn't just answers. Hers is also a third-party complaint, and it's a third-party complaint against Jones Works. What does this mean? We know that complaints are filed at the beginning of the lawsuit, and they're against each defendant. They're the accusations, the causes of action that are put against them that they're suing for. Now, a third-party complaint is a little bit different. It's also called an impleader. It's not a standalone separate lawsuit, but it's bringing someone else into the lawsuit. In this case, it's Jennifer bringing Jones Works. It's like saying, hey, I'm in this lawsuit because of you. You're liable for some or all of the claim against me, so I'm adding you as a third party. Now, what would that mean? If she is successfully added, if Jennifer is found liable, that means that Stephanie Jones and Jones Works are found liable too, so that if she ends up having to pay damages, Jones Works will have to pay for some, if not all, of those damages. Because here's the thing. We saw in a lot of those text messages, when this was happening, Jennifer Abel worked for Stephanie Jones at Jones Works. That's how Stephanie got these texts in the first place, because it was a company phone that she confiscated. So obviously, any and all of these texts that were provided by Jones Works to Blake were all made under the time period that she still worked for Stephanie Jones. So if she was working for Stephanie Jones, guess what, Stephanie Jones? That makes you liable for everything that she did while she was working for you. We also know, we saw by Justin's complaint and timeline, that a lot of these text messages were from Stephanie herself. Now, I'm betting that in what she gave to Blake, she took out any texts that were from her. But here's the thing. The other parties have those texts still that were from Stephanie. So here's how it goes with a third-party lawsuit. Let's say you were a patient and you had a procedure done, and it was done by a machine. So the doctor's using this machine, and somewhere in the process, the machine malfunctions and the patient's injured. Now, the patient is suing the doctor because it was under the doctor's care that this incident happened. But the doctor says, wait a minute, it was the machine's fault. We're bringing in the makers of this machine. They're getting sued too. They're going to pay these damages. Maybe all of the damages, maybe some of the damages, but it's their fault too. And so that's what happens. Both the doctor and the machine making company, they're both sued because of this incident. And that's exactly what Jennifer's saying here. If you want to say that this is what I was doing in these texts, if you want to say that this was a smear campaign that I was part of, well, I was doing it under the orders of my good old boss here, Stephanie Jones of Jones Works. So you got to sue her now, because I wasn't out here doing it for myself. I was doing it under the orders of my boss. This is something I'll bet Stephanie Jones did not see coming. Now, the complaint part of this document starts on page 72. We see they mention the parties, the jurisdiction and venue, and these are just to state why this is the appropriate court to bring this before, and then we get into the general allegations. And they are spicy, and you know I love my spice. This is not the childish, mocking, name-calling sort of stuff that we see from Team Blake, especially Ryan's motion to dismiss, but this is witty spice that Team Justin just seems to sprinkle just enough of. If we look at number 10, he seems to be praising her. And I call this the bless her heart approach. Because if you've heard bless her heart in that southern sense, that can be meant both sincerely, but often it's an insult that sounds like you're saying something nice. Oh, bless her heart. He talks about her disarming southern twang, her brass knuckle tactics, and then he says her high turnover of clients and employees. He talks about her successful career, the people that she's represented, but again, that wit, they mention a bunch of clients who have famously cut ties with her, where there was lots of accusations, lots of drama. So, unlike, like I said, Team Blake's straight out there name-calling mockery, this is just beautifully crafted wit. Oh, she made such a name for herself, and then lists these great clients that she's lost. Now, number 11 is important. At first, they seem to be praising her husband. The mention of him is important because who is he? A partner at WME. Do you recognize that name? Of course you do. This is the agency that fired Justin. Now, do you remember that the first time Ryan spoke to someone at the agency, he called Justin a predator, but nothing happened? Could it be because she was still repping Justin then? And then a second time Ryan mentions Justin being a predator, they fire Justin. Could it be by then things had gone sour between Justin and her? Because it's not based on principle. I mean, these people still rep Diddy, but they fire Justin? Doesn't it seem more likely that WME did this because of this husband and wife relationship of Jason being a partner of WME and his wife, Stephanie Jones of Jones Works, parting ways with him? Now, it mentioned something that's become a sickening thing to hear, a Hollywood power couple. We've heard the saying power corrupts, and it certainly seems to corrupt doubly when you have a power couple. Now we have Blake and Ryan power couple, and we have Stephanie and Jason, another power couple. Now, some little background about how Jennifer ended up at Jones Works. We see that she was actually a vice president of R&C PMK. This was a well-established 70-year-old PR firm with 53,000 employees, and she was the vice president. She wasn't even looking for a new job, but she was headhunted by Stephanie Jones in 2020. Jones Works needed someone in LA to run things from there, as she's stationed in New York. So Stephanie says, hey, I'll pay you more than you make now, and you'll lead a team for me. We have a little more bless your heart stuff in 14. When she's offered this job, people start warning her about Stephanie, saying she has a terrible reputation, she treats people horribly, she gets embroiled in disputes, she steals clients, she uses deceptive and unscrupulous means. But it seems Jennifer didn't pay attention and took the job. So her first year she signs as an at-will employee, working exclusively for Jones Works. But after that first year, she becomes a contracted employee. A lot more restrictions were added in order to stop her from leaving. We get into a little talk about choice of law, showing why Jennifer's case should be under California law, and then we get back into the work that she did for Stephanie Jones. She was the point person between JonesWorks and Wayfair. She ended up developing a good relationship with Wayfair, and after working for Stephanie for 4 years, as it became more and more toxic, and this kind of stuff is described where people called off, she would video call them to see if they were lying about being sick, and even in one case, she video called an employee who was at a funeral because she didn't believe that's where he really was. But she gives Stephanie Jones a very generous 6 weeks notice. 2 days before she's supposed to be terminated is when she comes in, is surrounded by security, is accused of having stolen stuff from the company, and her phone is taken from her. But now we get to the funny part, because she says, everything I'm accused of having done for Wayfair, I was doing under Stephanie's direction. Wayfair was your client. You told me to do this. You're in text messages with me doing this. I worked for you. You represented Justin and Wayfair. Was working under your company. I was obeying you. So as 33 says, all of the acts, inaction, and other conduct of Abel allegedly in the amended complaint and in support of plaintiff's claim were performed, if at all, by Abel as solely part of the discharge of her duties to JonesWorks or of her obedience to the directions of JonesWorks. So don't you just love it? You're suing me for doing my job and obeying my boss, which, by the way, was you. I mean, it's an absolute win. And if that's not enough, they pour salt into this wound, this self-induced wound made by Jones herself, because she says, not only am I suing you for suing me for doing what you ordered me to do, but according to California labor law, you have to pay for my attorney's fees to defend myself against you because as my employer, you're responsible for expenditures like this for your employees operating under your employ. I mean, could it get any better than this? I think not. You're suing me for what I did for you, and now you have to pay for what you're costing me in attorney's fees to sue me. As they say, at all relevant times, JonesWorks was Abel's employer. At all relevant times, Abel acted within the scope of her employment. At all relevant times, Wayfair Studios and Justin Baldoni were clients of JonesWorks. As Abel's employer, JonesWorks had exclusive responsibility for the actions or omissions that plaintiff's complaint attributes to Abel, that serve as the basis for plaintiff's claims and resulted in the alleged loss or damage incurred by plaintiff. Abel did not commit any wrongdoing herself that contributed to plaintiff's claims or the alleged loss or damage incurred by plaintiff. Accordingly, JonesWorks is obligated to indemnify Abel for any expenditures and losses, including attorney's fees, incurred in connection with plaintiff's claims. So this is what happens when you act on spite. You don't think it through reasonably. Stephanie was big mad, she wanted to strike, and she didn't think about what she was actually doing here. She thought she could sue these people, come out a winner, but now she's being added as a third party against the actions that she instructed her employee to do, and she has to pay for her employee's lawyer fees. But just the more we read of these filings, the more ridiculous the people on Blake's side are showing themselves to be. They overreact. I mean, first we have Blake claiming smear campaign when she's actually the person who waged a smear campaign. And that gets uncovered a little bit more every day. And Stephanie suing her employee for doing exactly what she told her employee to do. Well, let's talk about some other ways that these people have shown themselves recently, just this past week. Let's talk about some of the disgusting things that were uncovered. Now, in Blake's amended complaint, she started off with mocking Justin for words that he said in his books, his podcasts, or his TED Talk. It started off with an introduction. Are you confident enough to listen to the women in your life? To hear their ideas and their solutions? To hold their anguish and actually believe them, even if what they're saying is against you? And will you actually stand up and do something so that one day we don't have to live in a world where a woman has to risk everything and come forward to say the words, me too? Now this they took from Justin, Why I'm Done Trying to Be Man Enough from 2017. And they use this to sort of mock him and throw it in his face. And they take bits of this throughout the rest of this and try to turn it on him. They say that Ryan was a man who was holding his wife's anguish. Now let's talk about his 7-year-old baby daughter. What did we just find out this past week about her? There was a disgusting line in the Deadpool movie. And in the clip, you see what looks like a child and you hear what sounds like a child's voice. Now, in the days of AI, because what that child says is so disgusting, I think we all just assumed that it was just AI, that it wasn't actually a child in that outfit. And then even if they had a child pose in that outfit, that it wasn't actually a child's voice saying that. But no, an interview was uncovered with Ryan sitting there laughing with Sean Levy, and Ryan says, "Oh yeah, I'm Father of the Year." It turns out it was his 7-year-old daughter, and that she didn't want to say it. Now this man who claims that he holds his wife's anguish and accusing Justin of not listening to the women in his life and talking about this Me Too movement. But when his little 7-year-old daughter said, "I don't want to say this, Daddy," what did he do? Did he hold her anguish? Did he listen to her? And it turns out when you look at the actual script, what he asked her to say to her own father is so sickening I can't even say it. But it implied oral sex between her and her father. And when she didn't want to say it, he said, "Okay, I'll get another little kid." Manipulation. And so she did it. She said, "I'll do it." And then him and Sean sit there and laugh that they made her say it up to 500 times. What it ended up being, the line that they kept for the show, was then changed to this act between Wolverine and Deadpool instead of herself, but still disgusting for a 7-year-old, for any minor to be forced by an adult to say. He made her say this. And he says in the interview, to her credit, she didn't want to say it. Then why did you make her? Why would you even ask her to say this? It's so repulsive. He coerced his own daughter into saying sexual incestuous filth 500 times. And Blake wants to cry and sue because someone made eye contact with her while she was breastfeeding, because they showed a birth video when they were talking about how to stage a birthing scene that they were going to film. It wasn't put to her in a sexual way, and she lied about it and said that it was porn that they showed her, that they showed their wives naked. She lied about that. That's not even what happened. We've seen the picture now. We know she was lying now. But what her daughter went through, that's okay? Justin told her she was going to be hot because she was wearing a big coat over a onesie, and they were going into a bar that was 90 degrees and had no air conditioning. And she says she was harassed, but it's okay what happened to her little 7-year-old daughter by her own father. Justin said that an item of clothing that she was wearing was sexy because she kept saying she wanted her character's clothes to be sexy. She wanted this look because it's more sexy. But then when Justin says, "Oh, that garment, not you, that garment is sexy," he's getting sued for harassment. But it's okay. What happened to this 7-year-old girl? Blake says, "We were kissing and he sucked and nibbled on my lip." But we see the video and it's actually her doing it to him. And she's claiming harassment, but it's okay what happened to her 7-year-old daughter. Now this new footage comes out where it was not in the script. It was not directed by the director, but Blake decides her character's going to grab this guy in his private area. She adds it, actually does it, and that's fine. But she says that Justin kissing her during a dance scene that's supposed to be of them falling in love in a movie that she knows that there were going to be sex scenes between them. And she's saying, "This is harassment. I have to sue you because I'm so traumatized." But what Ryan did to their little girl is just fine. And she can grab this guy's actual genitals that was not in the script, not from the director. It was her own actions. And that's just fine. But Justin called her clothes sexy because that's what she wanted it to look like. She kept saying, "I want this to be more sexy. This will be more sexy." We've seen the texts. And when he says that's sexy, "Oh, you harassed me. I have to sue you." But it's okay for my little 7-year-old daughter to talk about oral sex between her character and her own father. That's fine. What's wrong with those people and anybody who supports them? I have had people come say nasty things to me to defend her. What's wrong with you people saying that? How are you defending this? You call us misogynists? That's appalling what he did to that little girl. Somebody needs to make sure that little girl's okay, because that's disgusting. We heard that Ryan made his love interest from Deadpool miserable by a sex scene that he made her film for 2 full days. She was traumatized by the end of that. She was so glad it was the only scene and that it wasn't any longer. 2 full days he made her film this scene over and over and over again. That's harassment. We saw him laughing like he's 12 years old, talking about Olivia Wilde's breasts. We know how he thinks when he's doing a sex scene because he told us all. So he can actually put his hands on someone, and Blake can actually put her hands on someone, and that's fine. And then you have Justin who didn't even do that, but he's getting sued. And what was Ryan's reaction to what he did to Olivia Wilde? Exposed her completely topless to the whole cast and crew. And what did he say in his 12-year-old mind? Oh, they won the lottery. And then he can't even be decent and respectful and not tell anybody about it. He's got to go out and tell the world about it to humiliate her some more. But that's fine. That's fine. But we better sue Justin. He said a big ugly onesie was sexy. You better sue that man. What else have we seen? How many times did Blake objectify Brandon? Turn him around and show his butt to the audience to get the audience talking about his butt. Objectifying him in front of all those people over and over again. Ryan did the same thing in that weird promotion he did with Brandon and his mom and Hugh Jackman. Held up a picture of Brandon's butt. Started talking about it. But that's fine. Because, but Jamie Heath made eye contact while Blake was covered up and breastfeeding. Better sue that man. Why do Blake and Ryan have separate standings for themselves than they do for others? I really, really want to know how people who support those two are okay with these horrifying things that they've both done. How do they dismiss those and say those are okay, but then go on the warpath after Justin, saying how horrible he is? Because he asked Jamie Heath to show his wife's home birth video, because they were about to film a birth scene, and he wanted to use this as an actual reference to something he wanted to portray on screen. Something he thought was a beautiful example of a birth scene. No one in recent years in Hollywood, except for their good buddy Harvey Weinstein, has done anything as despicable that I've heard of as Ryan and Blake. And I can't believe there are still people who think that they're victims, or that Blake's a victim. And I'm sorry, Blake, but your little PR attempt, hanging your dirty, unkempt hair over a whole batch of donuts in your friend's donut shop, is not going to save your reputation. And you know what? Like I keep saying, how big of a star are you when you have to be described as Deadpool's wife because you're not even recognized there in the donut shop on your own merit? You just better be glad you have at least that one last dragon with you to help you with your identity. Better hold on to him. You already apparently lost Taylor. Okay, so that's it for the answers. After these were filed, there was also a summons that we know was served from Jennifer Abel to Jonesworks. So that was already granted by the court and served. Also, Leslie Sloan and Vision PR's motion to stay discovery, because remember, they filed a motion to dismiss, and she also, like the New York Times, asked to get her discovery stayed so that she wouldn't have to provide any discovery until the court ruled on her motion to dismiss. And Judge Lyman said, sorry, it's denied. As will her motion to dismiss be, I'm sure. And we also had another memorandum in support of the New York Times motion to dismiss as an answer to the memorandum put out by Team Justin. It's 17 pages, so we will save that for another time. And maybe this week we'll see some more decisions made about all these motions to dismiss, and whether or not those decisions will lead to things like amended complaints to clean up some of the things as we move into April, and some more deadlines that will be coming up in our progression towards the trial. And I will do my best to keep you updated on anything that does get posted or decided this week. Till then, this is Cassidy O'Connell saying stay well and stay tuned.